I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. And my goal today is to clear up a little confusion between the escrow industry and the brokerage industry. And there's probably a lot of confusion on different topics, but I'm picking a narrow one today. And that topic is settlement statements. Oftentimes, brokers press escrow for a copy of the settlement statement that's provided by escrow at closing to the parties. Brokers often press escrow for a settlement statement that shows both the seller's column and the buyer's column, even when the broker represented only one of the parties. Some escrow companies will provide that settlement statement showing both parties' columns to the broker. Many others will not. Why? What's happened? Well, if you used your little time machine and went back in time, there was a time when every escrow company provided every broker and both parties on each side of the transaction a settlement statement showing both columns. In fact, during that time, Washington law created a requirement that brokers have in their transaction file a settlement statement showing both columns, one for buyer, one for seller. That requirement, the written requirement, has not changed. However, federal law changed with respect to confidentiality and protection of confidential information. So much so that many escrow companies have interpreted that federal law to limit their ability, to limit their authority even, to deliver one party's column to the other party or to the broker for the other party. In light of that change in federal law and practice by escrow companies, Department of Licensing has taken a different approach with respect to auditing. Even though the law, as it's still written, says a real estate firm must have both columns to the settlement statement in their transaction folder, DOL is not enforcing the provision that way. In fact, as long as the firm has a settlement statement in their transaction folder showing at least their client's column, DOL takes no position with respect to that transaction folder. DOL will not press for both columns. DOL will not complain if there is a settlement statement with both columns. So there's no concern by DOL over a privacy issue. If a firm happens to have a settlement statement showing both columns, that's not an issue. But if the firm only has a settlement statement showing their column alone, their client's column alone, that's also not a problem from DOL's auditing position. Will the law ever catch up with this issue? I don't know. I can't make you a promise about that one way or the other. But what you should know is that from an auditing perspective, from an enforcement standpoint, you and your firm are fine so long as in your firm's transaction folder, you have a settlement statement that shows at least your client's column in the settlement statement. If you have questions on this topic or any other, please visit warealtor.org, take a look through the Legal Hotline Library, or send me a question. Thank you for being a Washington REALTORS member.